By the end of this video, you will be in a position to explain what a force majeure is, explain whether or not force majeures are standardized, and explain issues to consider when using this clause. This video is as a result of a question that was asked by Miss Zepi Mwango from Zambia. So let's talk about force majeures. When we talk about contracts, we're talking about legally binding agreements. Of course, the issue is how you structure the agreement. What if a party fails to meet their contractual obligation? You might say that I'm just going to sue them or actually use one of the remedies available in that contract in case of a breach of a contract. Good. But what if the reason they failed to meet their contractual obligation is due to factors out of their control? Different legal theories have developed how to handle the need for parties to excuse themselves from their contractual obligations. Look at this example. Let's say you contract to build a school or to supply cereals, and then it becomes impossible due to floods or hurricane in the area that you're supposed to build that school or to supply those cereals. In this situation, you realize that it is impossible for you to continue with your construction or with your supply. So force majeure arises in such kind of a situation. The clause is based on the idea that nobody is held to the impossible, which gives us the principle of possibility is the limit of expectations. When trying to define force majeures, we often end up with definitions along the lines of risks beyond the reasonable control of a party, incurred not as a product or result of the negligence of the afflicted party, which have a materially adverse effect on the ability of such a party to perform its obligations. Now we can look at force majeures in two ways. One, it could be as a result of natural disasters. We're talking about things like earthquakes, the floods we talked about, basically all natural disasters. Or it could be as a result of actions relating to humans. For instance, war, whether declared or not, riots or mob violence, etc. There are three elements that generally make an event a force majeure. These are if the event occurs with or without human intervention. Number two, the event could not have reasonably been foreseen by the parties. Number three, the event was completely beyond the parties' control and they could not have prevented its consequences. Now, if at any point you are looking at this and you're thinking, I need to understand more about contracts, yes, there is a course I did on contract law, which is the link is in the video description. You can click on that, go check the course. It's really simplified, okay? And then you can understand things like formation of contracts, terms of contracts, remedies, things of that nature. Now, let's talk about whether or not force majeures are standardized. The truth is that often people tend to think that these clauses are standardized, and yet they are not. See, these clauses are creatures of contracts. What that means is that their interpretation will often, in fact, in most cases, will depend on whatever has been stated in the contract, which means if you're contracting, it is your duty to make sure that you've defined what the force majeure is, its consequences, and pretty much its application in that contract, because it is not one of those terms that are just standard. In fact, if you look at English contracts, or if you look at common law, you realize that they really don't have, like force majeures. What they in fact have is what is referred to as frustration clauses, okay, which are basically the doctrine of frustration, which operates in this manner. The doctrine of frustration is of the idea that when circumstances are in a contract, or rather when circumstances occur in a contract, bringing further fulfillment of that contract, making further fulfillment of that contract impossible, then the contract is said to have been frustrated. So an example there could be the flood. So you see, in that contract, rather in the English contracts, you end up with the doctrine of frustration, or whatever the frustration. And yet in some contracts you end up with force majeure. So the point is, if you see it in a contract, the interpretation will depend on whatever it is that the parties wrote in that contract. So they are not standard. Now the third thing you have to talk about is things to consider, or factors to consider when you're using this clause. The factors to consider will include, number one, have you properly defined what constitutes a force majeure in the contract, or is it ambiguous? Number two, who will bear the risk should the clause become active? Number 3, what are the consequences of a force majeure event? And number 4, to what extent, if any, should the contractor continue to be paid even where it's unable to perform its obligation? And finally, should there be a termination in case of extended force majeure events? Look, when you're talking about force majeures, okay, imagine a situation where someone is giving you money, or rather someone is financing a contract. That person expects return on their investment. And so they really don't want things that are going to give you an excuse not to perform that contract, which means lenders don't really like it when force majeures are in contracts. In fact, lenders don't like it when we have clauses that excuse contractors from fulfilling those contracts. So the point is, if you're going to use one of these, you have to be careful. Again, look, it's not just about being careful, it's about understanding the implication of a force majeure in the contract. So up to there, if you have any question, do let me know. Again, remember, if you don't understand contract law, there's a course I did about it. The link is in the video description. Check it out. Again, if you have any question, let me know through Facebook, YouTube, whichever place is it that you're watching this video from. I'm Moses from Zerite Network, and I'll see you in the next video.